You're still here.
I am. This is the last time the whole summer.
This is it?
Mm-hmm.
Oh, kind of sad. Anyway, go ahead.
Good afternoon, Your Honor. Alex Parks on behalf of Mr. Moore Jones.
More Jones. All right. What are we doing?
Your Honor, we spoke with the prosecution this morning about a potential plea deal. We are asking for an adjournment in this matter to discuss the offer further and to give our client time to collect the restitution.
Okay. So part of the plea is restitution. So timing wise, how much time do you have a number, and then how much time is it going to take him to try to?
We do have a number. A few weeks, Your Honor.
A few weeks. It's your last time. You're going to make this difficult on me, aren't you? How much, young man, you've seen the number that they have?
Yeah.
Okay. How much time is it going to take you to try to come up with that?
Maybe 2 weeks, maybe.
About 2 weeks, you're going to be able to? Okay, I don't know what the number is, but that's fine. All right, let me do this.
It's not that bad, but it's 700.
It's 700? It's going to take you 2 weeks to come up with that?
I mean, I'll work, but I got priorities. I mean, I know this part of my priorities.
No, okay, no. Stop talking, because you're going to get yourself in trouble. No, you saved that one.
No, I got I'm not doing one payment. I don't want to do that. That's all.
You what now?
Big payment. I don't want to do that. I can't do that.
Can't do what?
700 at once. That's what I was saying.
He'll have it in a couple of weeks.
Right. That's all I'm trying to figure out is how long it's going to take you to do that without messing your whole self up. I'm just trying to set a date that you can try to make it happen.
Yeah.
And you're saying a couple weeks that you think you can do that.
I work every day. Yeah, I said.
Well, I know, but I'm just saying you also got bills. Yeah, I mean, we're just trying to give you enough time so you can do it without.
I said 2 weeks though.
So let's do September 5th is great, Your Honor.
You know what? I'll just make it next week, and then you don't have it, right?
Yeah.
I mean, I'm just trying to give you time, young man.
It is what it is.
Oh no, he ain't gonna say it is what it is to me. He can sit down and you can check him and then have him brought back up.
Thank you, Your Honor.
And you keep shaking your head, and then I'll show you what I'll do. I refuse to be nice or understanding anymore today. No, ma'am. That includes your case too. All right? Work on. Everybody's like, really? Nicole and Nelson.
Your Honor, Alex Parks on behalf of Mr. Moore Jones.
Marcus Moore Jones.
We're requesting a 1-month adjournment in this matter.
How much?
1 month.
That'd be enough time for you to get it all together and get. Young man, do you understand what I was trying to do? I was trying to make it easier on you.
I apologize. It was a misunderstanding.
Right. And I just say this. The problem is that you come in, I'm just trying to make it easy on you so you're not stretching it.
All right.
And your attitude almost got you into a whole lot of trouble that wouldn't have even been worth it. Understand me? So just listen to folks. Conference, September 5th, 2024. 9 a.m. or as your invite indicates, bond will continue. Is he paying? You don't need an order for him to be able to pay that to the court, do you? Or how were you guys going to do that?
I believe Mr. Moore Jones had made a comment that he didn't want to just do it all in one lump sum.
Right.
So if he wishes to make payments, an order can be made so that can happen. I don't have an issue with that. Right? If we submit an order to the court allowing payments to be made on the restitution.
Yes. If you submit an order that we then hold it for payment, we'd hold it as what technically a bond, but to be paid out for restitution. That way, as he gets paid through this period, or as he has the money, he can pay it here so that he doesn't have to come up with it all at once and try to hold it or do whatever.
Okay. Thank you.
All right.
Thank you.
Hey. And next time, just check the attitude, man.
All right.
Okay? Because he hasn't done much today, and he almost had to take you. All right, take care. Thank you for signing back on, Mr. Miller.
Yes, Your Honor.
All right, and Mr. Miller, I want to thank you for something else. All right, can I?
Yes, Your Honor.
So before court began, you were on. We had the screen turned on. You were smoking.
A cigarette.
Hold on. And my staff told you not to smoke, and you immediately put it out and then apologized for that. And they appreciated the fact that you apologized and that you immediately took care of it. Okay?
Thank you, Your Honor.
So thank you for that, sir. Take care, Ms. Miller.
You too. Thank you.
And what did you want to tell me?
I just want to know if there's any way possible that the no contact can be lifted anytime soon.
And why do you ask?
Because I don't feel endangered by Landon. We have an apartment together. I feel very, very safe with him. We have 2 cats. We have jobs. It's just a lot harder to do it alone. And I never wanted him to be taken out of the apartment.
All right. You don't work at the same place, do you?
No, we don't.
Okay. All right. Anything else you want to tell me?
No.
Okay. Thank you.
Yeah.
Anything from the people on?
Yeah, Your Honor, for the record, the people opposing changing the bond at the time of the arraignment, we did include in one of the court that made the bond decision and the no contact order to be aware that our office was concerned for this victim. Her job had seen numerous bruises on her body, and that the defendant had threatened the victim with weapons in the past. The knife pulled out during this incident, but the victim did relate to police that the defendant did not threaten her with this time. Fortunately, people do believe there is a history of unreported domestic violence in this situation.
And just so that I'm clear, there was a knife that was pulled out,
but not used to threaten them. But in the past, there have been threats of weapons.
Okay. Anything from the defense? You can come back on.
Nothing too much further, Your Honor. I was unaware that the claim witness in this matter would be speaking today. Of course, we would have no objection to a bond modification allowing Mr. Carr to return to the apartment. He has expressed to me that that is their shared residence and he does wish to return back there. However, he did not know how she felt about it, as of course he has not had any contact with her since the arraignment. Nothing further to add from us though, Your Honor.
All right. I guess I'm concerned about this knife. So it was brought out but not used.
It was not used to threaten, but it was pulled out during this incident.
Do we have any, I guess, reason as to why it was pulled out?
And the exact statement at the time when the victim spoke to the police that evening was that the defendant, while driving, took out a pocket knife, began playing with it, flicking it open and closed over and over again while driving over 90 miles an hour. She felt threatened, but he didn't threaten her directly with the knife. She, in the past, he would play with knives, sometimes opening it, putting it to her stomach and telling her, don't move, things like that.
Until we can get a better handle on that, I'm not going to change any of the bond conditions. Given that and given what I'm hearing, that there were past issues, as well as the fact that, although not used, there was a weapon involved while driving at a high rate of speed. So I'm not going to change the bond condition. I'm going to leave it as that. Thank you. All right. What did you want to tell me?
I am requesting a slight modification in the no contact order. I would like verbal contact because we have 4 children. And I don't want any middlemen kind of trailing our children between him and I, which would be his parents. And there's always been like confusion and miscommunication in the past. So I would just like for it to be straightforward. Hi, would you like to see the kids? I'll bring them on over. I have a vehicle. He has a motorcycle. So it would just work best that way.
I see.
Yeah.
And how old are the children?
They are 5, 4, 2 and 4 months. Sorry.
Wow.
Yeah. And they all love him very, very much. So I'm trying to get them to see him kind of as soon as possible.
Okay.
Yeah.
Anything else you're going to tell me?
No.
All right.
That's
Fantastic.
it. That's
Any
it.
response from the people?
Oh, okay.
Your Honor, at this time, we are not in favor of modifying the no contact order to be complete unlimited contact as far as a slight modification using perhaps Our Family Wizard or some other program. If that's available, I'm not sure it would be, because I do not think that there is a circuit court case for custody happening. Don't think that that's going on right now. I think there's no formal arrangement. Concerns here is that here we not only have the domestic violence, we also have the legal entry. So there's a little bit more going on in this case. Yeah, at time of the police contact, the victim did tell police that defendant has been abusive to her for the entire duration of their 6-year relationship, and that he thinks he could come over whenever he wants because the kids are there. That's a concern of the people. I'll also say for the record, the defendant does have a juvenile adjudication for UDA and DV in 2013. Had a 2018 conviction for possession of controlled substance that he got cited for, and is a CPL holder. Or maybe not.
Maybe not at this point.
Was a CPL holder, I should say.
Yes. Go ahead.
Thank you, Your Honor. Likewise, I was not aware that this request was going to be made today. However, I would ask the court grant the request for the bond modification so that Mr. Cook can have contact with her in this matter in order verbal contact for purposes of childcare. I do understand that Mr. Cook does have 4 children in common with her. We would ask the court allow for that communication to happen. Otherwise, I have nothing further, Your Honor.
All right. Ms. Bell, how do you envision this contact happening? I guess if you want to come back up, if you would. Sorry.
I wouldn't mind text messages or phone calls being made. He contacts our 5-year-old via FaceTime every day. So I'm like totally fine with that. If he wants to see the kids, I'd be more than happy to drop them off at his parents', which is where he lives right now. I'm completely okay with that.
Okay, so, but it wouldn't be a circumstance where
he would be coming over. No.
Yeah, no.
No, I want my home to kind of be like off limits for myself and the kids. I want it to be my place of peace, but I do also want my children to be with him, as my 5-year-old is already like, where's dad? And I'm like, he's working. So
gotcha.
Yeah.
Okay.
Get it figured out.
So it wouldn't be an issue of him through this mechanism, if this were to happen,
right,
having any reason to believe that he would be able to just come over.
Right. And we also, all of their birthdays, our 3 oldest, their birthdays are within like a 2.5-week time span. So we have a giant family birthday party in the summer, which is also coming up, which I would also like for us to obviously be in the public setting of both of our families at the birthday party kind of thing. It's more of just like an alone in-home situation that I'm not comfortable with as much, but yeah.
Okay.
You understand where I'm coming from?
I get it.
Okay.
Okay. Okay. Thank you.
Thank you very much.
What I will do in this case is well, first of all, let me address one thing. The My Family Wizard, I think the cost with that probably would be a cost that they couldn't afford at this point in time. And there's nothing pending before the family court. What I will allow, I'll modify the no contact provision in this instance to allow written, electronic, or verbal contact only regarding the minor children. So that's the only reason that you would have to contact her. You understand that, sir? Okay. And if the contact in any way gets abusive in terms of its frequency or otherwise, then the court will stop it altogether if that's what happens. Okay. Thank you. With reference to the party upcoming, counsel, you'll probably need to talk with your client and everything once things are more formalized and potentially submit an order to allow that to occur.
Thank you, Your Honor.
Thank you. About the cases you had out before Judge Fresh Hour, are you done with those?
No, yes. Yeah.
Okay.
Sorry.
Eric, which one?
Yes, sir. I'm done. Your Honor, I didn't do any assault and battery.
Well, hold on. Eric, you know how this works.
Okay, keep my mouth shut.
There you go.
I learned, sorry.
Yeah, he learned.
Thank you.
After he told me about the magic bullet and it.
Oh, no, oh, no.
Yeah, you think I'd ever forget that?
I don't think you.
Mr. Brown?
Yes, sir.
You remember Mr. Vermeulen?
Yes, sir.
And the magic bullet?
Yeah,
that took out like 3 deer or something? Yeah.
5 of them.
5 of them, all at one time. All right, so. All right. So what do you want me to do?
We could go out to after that next pre-trial date. I can see about trying to get something wrapped up on everything, Your Honor.
Okay, so he's on 21st. So I'll go to. Well, he appears before me on the 21st. I can set it for the 22nd or the 29th, which would you?
22nd is great.
22nd. Probable cause adjourned August 22nd, 2024, 9 a.m.
Thank you very much.
Bond continued.
Thank you, Judge.
Right.
Can I have a PR, please? Please, my sister will pick me up in Pinckney. I hadn't had my medication. I didn't do any crimes. Can you please give me a PR? Judge, Your Honor, you know me. I'm not going to let you down. I promise you. I will not let you down. Please, Judge Simpson.
Any response from the people on that?
Yes, Your Honor, thank you. He will be held in your other file until the 21st anyway. There's a 5,000 cash surety bond on that case, and it's an assault battery file. These assaultive crimes were committed 2 days back to back. He assaulted 3 civilians, and then on August 3rd, he assaulted a police officer.
So the other case that's coming before me involves 3 civilians.
Right.
I didn't insult.
Eric. What I'm going to do at this point, I moved this up a week.
Thank you.
So I'm trying not to hold you as long as I can. That other case, I'll be able to take a look at on the 21st. But at this time, it wouldn't matter whether I give you a PR on this one because you're going to be held on the other one. So I'll just continue his bond on this matter.
Thank you, Judge.
Thank you, Your Honor.
Thank you. Because it's his bond on this one's only $100.
Thank you, Judge. Appreciate it.
Have a good day.
You do the same, Eric.
Good afternoon, Your Honor.
Where's the rest of his paint?
It's
Oh, I'm sorry.
warm today, Your Honor.
Huh?
It's just a little warm today. But if you would like him to wear pants in the future, I will make sure that is
Warm today?
little warm.
As opposed to any other day in August, it's what?
I'll wear Dockers next time. You know?
What do you say?
He said he'll wear pants next time.
Okay, just checking. He understood what I was saying.
Yep.
See, he was trying to defend you. Didn't need to. I needed to give you a reminder. All right, go ahead.